Hey, this is Daniel O'Connor with the Brighton O'Connor Law Firm. Today, I'm talking about what happens if your will is lost or if the person for whom you're supposed to probate their will, and you can't find their will. So that's not a good situation, but it happens sometimes. So today we're going to talk about what happens if it is lost, and two, what can you do to prevent it from being lost, assuming you're not already in that situation. So Georgia law provides that a court is supposed to presume that if your will is lost or your executor can't find the original will, so the one you wet signed, that you revoke the will, which is as if you don't have a will at all. So that's probably not good. Usually when the original is lost, the result is like you didn't even have a will at all. And your property and estate will be handled under the law of intestate succession, which prescribes who gets your property, who has priority to be your administrator, and that type of thing. Now, it is possible to rebut the presumption of revocation. Your executor or whoever's putting forth your will for probate will have to prove two different things. One is that they've got a copy that's a true copy of the original, and two, they've got to show by preponderance of the evidence, more likely than not, that you did not, the decedent, the dead person who made a will, they have to prove that you did not revoke your will. An example would be the will burned up in a house fire. It was an accident and they didn't really intend to revoke it. Or your estranged son Joe, who was written out, stole it. That's the kind of thing that you've got to prove or show to demonstrate that the will was not revoked. And that's not easy to do, particularly if all of the heirs, the people who would get your property if there was no will, don't agree. Now, if everybody agrees, it's a little bit easier to probate a copy of a will. And we do that probably a couple times a year. This situation comes up with the states that we handle. But when someone objects, it is not an easy situation to probate a copy. So, I mean, probate is enough jumping through hoops as it is without throwing a monkey wrench like that in there. And sometimes it could be a really bad situation. And as I always tell people, we don't know how to do seances with the dead. So it's not like the dead person can tell the court what happened to their will. So that's why it's so important to keep the original. So what are some things you can do to make sure that the original doesn't get lost? One is, I have always recommended people put in a safe or a safe deposit box or something like that. But the problem is, sometimes the people who are still around after you're dead don't know where you put it. So maybe your will is safe from fire or theft, but it's not safe. It's not in a secure place where it'll be found. So I always encourage people to communicate with the person they've nominated as their executor, and probably the backup too, and probably their attorney, and let them know exactly where it is. Because it's often the case, likely, that the will is somewhere, but the executor can't find it, which is just as good as it being lost. So again, that's not good. Some of the most stressed out clients I've ever had are people who are trying to handle an estate, but they can't find the will, which will upset the expectations of the decedent and probably everybody else. So please don't put your family in that situation. The second thing you might do is ask your lawyer if they'll keep your will. I never, in my prior 10 years of practicing, agreed to keep original wills. Primarily because I didn't want to accept the responsibility for that or the liability if you know I lost it or my building burned down or something like that. But I think I've come up with a system, and that's one thing I'm going to start offering, is storage of of wills, which that won't be free, but it'll be a part of people who become a member of our personal family lawyer program, or who are agreeable to paying a fee for storage. That's not too much. We'll have a system for protecting wills, making sure the executor knows who to ask to get it, and also we'll have contingencies for any kind of casualty. Because if something happens to the will and it's in our possession, it really won't be a problem to prove what exactly happened. And I think we're equipped to keep the records to demonstrate that. So those are a couple things to think about. The bottom line is keeping your original will safe is very important, and also being sure that once you die, somebody can find it. The original will is one of those things that still has some very formal rules about having an original wet signed document. A lot of documents you can rely upon a copy. A will is not one of those. We don't mess around with those. And so just always remember that your original will is something you have to keep safe. Somebody needs to know where it is. Thank you for listening today. I hope you found this helpful, and I hope it'll encourage you to act on this. And until next time, take care.